5 seconds. Start. The benefit of pension is a condition of service. It is clear from the scheme of regulations that an employee would qualify for pension provided he meets the requirements envisaged under the Civil Service Regulations. It is well settled that the conditions of recruitment cannot be relaxed and recruitment resorted to dehorse the statutory rules is a nullity. The authoritative decisions in this regard rendered by the Apex Court in case of State of Karnataka versus Uma Devi 2006 for SCC 1 lays down the law. When we analyze the petitioner's argument from this standpoint, a daily wage employee, in our considered opinion, cannot be equated with a regularly selected person. The Apex Court, in a catena of judgments, has spelled out the distinction. Therefore, the classification based on the recruitment by following due procedure under the rules and through backdoor entry is well recognized. Once the classification in the matter of recruitment is recognized, distinguishably any challenge to a provision which grants protection of pension to the requisite length of substantive service alone would be misconceived and contrary to the spirit of Article 16 of the Constitution of India. We may safely observe that any challenge to the validity of Regulation 370 which leads to diminish the distinction between the valid recruitment as per rules and backdoor entry is clearly an attempt to equate two unequal and distinguishable situations which have rightly been classified under Regulation 370. For achieving the goal of Article 16 of the Constitution of India, it is essential to draw such a distinction, and the same would not impinge upon any fundamental right available to the petitioner under Article 14 of the Constitution of India, as such challenge to the validity of Regulation 370 fails. The petitioner in the instant case has not offered any justification as to how a daily wage employee can be equated with the employees who are recruited in service by following the stringent process of recruitment. The services rendered by a regular employee, for that matter, can neither be equalized in terms of financial implications nor treated at par with the services of a daily wage employee unless the rules so permit. Now, coming to the judgment placed reliance upon by the petitioner, suffice it to say that the case of the petitioner is governed under a different set of rules. The petitioner has also not laid any foundation for establishing equivalence of his daily wage services to be at par with the services of a regularly recruited confirmed employee. Even the right to hold the post prior to the date of his regularization in a substantive capacity is not established or construed in the light of any statutory rule, and it is also not made out as to how payment made to the petitioner out of contingencies may be treated as regular salary. The writ petition has come to be filed after 2 years from the date of petitioner's retirement, and that too under the garb of challenging the validity of Regulation 370, which is clearly an afterthought.